matter before the court is Penobscot 24224, Stewart, Carney et al. Versus Hancock County et al. And counsel are present, and those attorneys who are going to be arguing, if you would identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Peter Marchesi, and I represent all of the county defendants other than Mr. Wall's client.
And I'm John Wall, and I represent Respondent Gilbert Dumont in this case.
Good morning, Your Honors. I'm Scott Lynch. I represent the appellees, Stewart, Carney et al.
Thank you. We are being streamed live on the web by both audio and video. And if counsel are ready to proceed, Mr. Marchesi, I understand you will lead off. We'd be happy to hear your arguments.
Thank you, Madam Chief Justice, Associate Justices. Again, Pete Marchesi on behalf of the county respondents other than Ms. Dumond. My time is short. I'll jump right to it. This case presents the important question: what is the scope and the reach of the Maine Health Security Act with respect to who claims can be brought against? The answer significantly impacts not only jails and jail employees, but also other institutions and their employees, such as schools, colleges, universities, and group homes. If a county jail and its correctional professionals can be respondents in a Health Security Act claim merely because the jail is required to contract with medical professionals to provide care to inmates, what about schools and school teachers? Are we to say that merely because an educational institution retains a medical professional, perhaps a nurse, to minister to its students, that it and its teachers, who may be called upon to render aid to an injured student, can also be respondents in a claim under the Health Security Act? These cases are becoming more frequent, prevalent indeed, and in fact, as we speak, there's another one on this court's docket. This court has recognized time and again that the clear legislative intent behind the Health Security Act was to protect access to medical malpractice insurance to those in the healthcare industry. Yet counties and county employees have no need for such insurance. They're already immune from tort liability. It's questionable whether non-healthcare entities would even qualify to be able to procure medical malpractice insurance. And even if they could and did procure such insurance, it would be at their peril, as, at least to the counties, they would then waive the statutory immunity which they already enjoy under the Tort Claims Act. I urge the court to take the opportunity of this case to insist that those bringing claims under the Health Security Act and courts reviewing those claims hew to the statutory definitions of healthcare providers and healthcare practitioners as set forth in the Act, and to stem the veritable explosion of cases that are being filed under the Health Security Act against institutions and individuals who are not employed or involved in the healthcare field. As respects this case in particular, there are two groups of entities that can, I won't say be liable, but who can be respondents under the Health Security Act. They're the providers, which are institutions, hospitals, clinics, nursing homes, and as the statute says, other facilities, and we may get into that on the one hand, and individuals on the other, doctors, podiatrists, chiropractors, the list goes on and on. And we have both groups in this case. We have institutions and we have individuals. The simplest way to resolve the question of whether the individuals should remain in the case is to look at the second amended notice of claim, which is the operative notice of claim.
Can we actually, before we dive into the Health Security Act, just want to ask you a question that may be more appropriately addressed to your colleague there. But as a threshold issue, the Maine Tort Claims Act immunity, were employee Dumont's duties discretionary as alleged in the complaint here?
Well, I'll answer that question, Justice Mead, on behalf of my clients,
right.
and I think that will apply equally to Ms. Dumont. And the answer is, as a matter of law, under this court's pronouncements in both Erskine and Roberts, the answer is no.
You're suggesting that as a matter of law, as a result of our pronouncements, whatever jails, corrections officers do, if it's related to inmates, they're immune?
What Roberts and Erskine say, yes, Your Honor, essentially.
They essentially can never be. What if, if it's intentional and deliberate indifference, are you saying that they cannot be held liable?
Well, they cannot be held liable under tort law. Now, there certainly can be held liable for deliberate indifference under Section 1983.
Well, let me read a ruling from our brethren in the federal district court. Where they say that where there's a deliberate, an Eighth Amendment, Section 1983, with a pendant MTCA, that the defendant is, quote, not entitled to summary judgment on a Maine Tort Claims Act by dint of an absolute immunity defense that he was acting within the scope of the discretion. So they're saying that when it's deliberately indifferent, it could fall outside the discretionary function, and they are relying on Richards versus Town of Elliott, which had to do with excessive force, and they extrapolate that to deliberate indifference. So if you and there is a federal case that's pending, and shouldn't we leave the Tort Claim Act with them with a deliberate indifference because the issues relating to immunity are entwined with the deliberate indifference federal claims?
So I'd answer that question at least two ways, Justice Conner. One would be that that is a federal court interpreting this court's precedent, and it is not binding on this court. This court's precedent is clear in both Erskine and Roberts that the care and custody of inmates is a matter of discretion.
We did not address in those cases deliberate indifference.
But deliberate indifference is an entirely different species of liability. That's a constitutional
I understand
standard.
it may be a species of liability under 1983, but we did not address in those cases as to whether deliberate indifference would take them out of the immunity for discretionary function.
So you're correct. You didn't discuss that.
In Richards, we did say that when an officer uses excessive force, they have exceeded the discretion, so that the discretionary exception did not apply.
So those cases really are distinguishable in any event because there's no allegation here to avoid the immunity that there was deliberate indifference.
Can I just take you one
allegations
step
here are negligence.
Can I take you, on the short time you have remaining here?
Yes.
Plaintiffs are saying here basically that upon report of A, B, and C, that the jail employee must do D, E, F. There's no discretion involved. In other words, if the red light goes on, they have to push the green button. No discretion. Your response?
And I understand that's what they're saying, but
Yes.
the law says otherwise. The law says, and we've cited some case law in the briefs, both appellants have, to the effect that where the court has said that it is a matter of discretion as a matter of law, the fact that there's a particular obligation to do a particular thing doesn't remove the discretion. And I'd simply remind the court that under 8111(1)(c) of Title 14, the discretionary function immunity applies even where the discretion is exceeded or abused.
Thank you, counsel.
Thank you, Your Honors.
Attorney Wall?
Yes, thank you, Your Honor, and may it please the court. I don't have any reserved time, so I'm happy to answer any questions out of the
I
gate.
think you know what the question is.
Do you think that anybody associated with prisons are absolutely immune for whatever they do to an inmate because it relates to management and supervision?
I believe that what this court has held in Erskine and Roberts is that the supervision of inmates is a core discretionary function, and therefore, in the context of this case,
So you can torture them?
As a matter of tort, I think what you're...
They're immune from a tort claim under the state law for torturing inmates.
I think that would fall outside of basically your scope of your role as a corrections officer if you were to torture somebody. So you're outside of the Main Tort Claims Act altogether.
Okay, so
Along the-
torturing would be outside. How about deliberate indifference?
Well, I've never seen that applied in the context of a Main Tort Claims Act case where you're talking about the concept of deliberate indifference, which is, of course,
Well,
it's a term of art.
in the federal court where they are pendant to the Section 1983s.
It is a term of art under federal law. I acknowledge that, Your Honor, but I don't think I've ever seen it applied or utilized as the theory of liability for the purposes of Main Tort Claims Act issue. Main Tort Claims Act, based upon the law that I've seen, is evaluated based upon the facts of the case and the prevailing law. In this case, it would be Erskine and Roberts in dealing with the supervision of inmates.
Does your client's role as part of the medical process going on, medical symptoms are reported, it comes to her, she passes it on to the person who does the next thing. So she's in that chain, I'll call it a chain of custody of information that directly relates to medical care. Is she a medical care provider?
No, Your Honor.
Why not?
Because the role that she provides, even under that factual scenario, is simply one of supervision of inmates.
Well, isn't
She
it
is not.
facilitation of, I mean, we understand she's not a licensed practitioner. I get that. But isn't she facilitating, and doesn't the jail as a whole have the obligation to facilitate the provision of medical services, whether they do it themselves or whether they subcontract it to somebody else?
And that may be an issue with regard to the county that the court can address. From the perspective of my client, to the extent she, as alleged in this case, obtained information which suggested required follow-up, there was an unusual situation that policy requires a report, her obligation is to relay that information along to people who are medical providers.
Aren't there fact questions in this case as to the discretionary function for your client?
No, Your
And
Honor.
if there are fact questions, shouldn't we be dismissing an interlocutory appeal? And that is the elephant in the room. I mean, all of this is interlocutory.
Well, that's true, Your Honor, but there are no factual issues that bear upon the the discretionary immunity issue, because as I've indicated, as this court has indicated in Erskine and Roberts, the supervision of inmates is a discretionary function, is a core discretionary function.
Is there an inconsistency in what you just said? You just said if a report is made, her role is just to pass it along. Just she's not a medical care provider. But you're also saying it's a discretionary role she's doing. Are those two concepts?
Exactly, Your Honor, and it's up to her to decide whether or not it's the kind of information that needs to be passed along. First of all, it's entirely within her supervision of the inmates, and therefore it's discretionary in and of itself.
But didn't Lieutenant Shepard testify that she was mandated to report suicidal behavior when it's reported?
And the issue was the information that was provided to her such that it was indicative of that kind of issue, such that she, under the policy,
Well, either
was required to pass
it's
along.
undisputed for purposes of the motion, in which case we can rule on it, or if it's disputed, which it seems to be what you are saying, then we should not be dealing with that on an interlocutory appeal.
And which part is not disputed, Your Honor?
What her obligation was, and if you're disputing what information she actually got and whether that was indicative.
No, Your Honor, I think the record is clear in terms of what's alleged, the information she received, and I think it's clear from the record what they indicate the policies say in that regard. What is the link between those is she has to make a decision based upon the information that's in the record as to whether or not this requires her to turn around and make a report. That's
Well, she doesn't have to make a decision if it's reported to her that somebody is suicidal. There's no question about whether she has to report that, is there?
And as this court has already held in cases like Selby and Doucette and Norton, other policies that have required mandatory type of activities or prohibited certain types of activities.
But the captain gave testimony that Dumond failed to follow the mandatory policy. Doesn't that in itself raise issues of fact about whether it may be a discretionary function, but the discretion has to be exercised in order for it to fall within that exception?
No, Your Honor, because that's exactly what happened in Doucette when a dispatcher failed to log information that she was required to log under the policies that governed her activities. It's the same as Selby, where an officer engaged in a pursuit of somebody for a traffic violation when the policy said you're not allowed to.
Is logging information ministerial?
Well, it was part of the policy related to the activities, and this court held that it was discretionary
But in
on the part of the...
Doucette, we said that Thomas was called on to exercise judgment in evaluating incoming calls and determining how those calls should be handled. So obviously, Thomas had to make some decisions, but I think as Justice Horton just pointed out here, upon a report of A, B, and C, it requires that the recipient do D, E, and F. Not discretionary. There's no judgment involved in that.
And I would suggest, Your Honor, that any time you receive information as a corrections officer, you're required to evaluate it and decide what happens next. And that is, as this court has said, these controls on the behavior of the individual employees doesn't change the underlying discretionary nature of their activity. And as this court has held in Erskine and Roberts, that is, the core function is of supervision of inmates.
Thank you, counsel.
Thank you, Your Honor.
Attorney Lynch.
Good morning, Your Honor. Your Honors, the appellants abandoned a suicidal inmate, and she perished because a guard chose to go home at the end of her shift rather than follow a directly circumscribed, very specific stop sign. This happens, you do only this. Mr. Attorney Marchesi mentioned that there's another case before you as an example of a floodgate that's about to open. Well, if there's a floodgate, it's about Hancock County, because that case that's just been docketed is another jail suicide, same players in many respects, another hanging in the jail because people didn't follow the mandatory policies. So you now have one that's coming up on a briefing schedule involving many of these same players. I want to go to the point that this is an interlocutory appeal, and they're trying to fall under the immunity exception to the interlocutory appeal. But as you have said, in Wilcox and Bean was in 2022, that if there's a question of fact about insurance coverage, you cannot avail yourself of that safe harbor as an exception to the final judgment rule. And here, they didn't put the insurance policy in play. They only provided the certificate of insurance, and the certificate insurance says there's coverage for incidental malpractice. Well, that term is not defined anywhere on the certificate of insurance, but incidental malpractice generally means it isn't the only thing that you do at your facility, but you are providing, as part of what you do, care. So I was asked at oral argument in the Superior Court, I believe, that, you know, what about a police officer that provides Narcan? Are they acting as a health care provider? And my answer to that question is yes, in that limited, they're trained, they're certified to do that, they're providing a life-saving activity. If they do so incorrectly, we may not like where we are with jails and police officers providing that care, but it is health care. It is a health care service. Because you don't have the insurance policy, which says that provides all the definitions, the inclusions and exclusions, and just the certificate of insurance, they have not met their burden, as the Superior Court said, in showing that they fall within, that they're entitled to immunity. And you don't have that even now. It escapes me why they didn't put it in their reply memo. It makes me think that there must be insurance. And it would seem to me unreasonable to have coverage for employees and then not allow access to a wrong party when those taxpayer dollars were spent to acquire the insurance. And then, in order for them to prevail, they run squarely into Gaffner.
Now, this insurance policy here, as I understand it, it's in wide use. This is a frequently used and implemented policy, is that correct?
There are different versions of it depending on which risk pool, and typically they're reissued each year, and they vary, as most insurance policies do.
Well, if the other policies also include this coverage for incidental malpractice, do you have any cases where that's ever been construed?
There was only one case in North Carolina that construed the definition of incidental malpractice. I actually briefed that case in the Pool case, which is the other one that's coming before you, but it wasn't an issue in this case.
But your issue is, this isn't the insurance policy. This is essentially like a deck page.
It's a deck page.
It's pretty detailed, though, isn't it? I mean, I understand at the end it says coverage contained in the coverage document and referenced in this coverage certificate, et cetera. I mean, this is not the actual coverage.
Right. This court has said that these municipal pool documents are to be construed like we construe insurance.
Okay, but my point would be that this member coverage certificate is actually far more detailed than the typical deck page that you might get in another insurance policy in the world of private insurance. The deck page simply says, here's the limits or things like that, and what's included, what's not. This actually spells it out pretty well, doesn't it?
I don't agree exactly, Your Honor. This is an in-between. It's much more detailed than like an automobile deck page would be, but it's nowhere near as detailed as a commercial liability insurance.
Let me just
deck
ask
page would be.
hypothetically, suppose they did put in the entire coverage, you got the whole policy there, and it sort of conforms to what the chief has pointed out here, that they're not providing insurance for anything that the MTCA gives immunity on. I mean, why would they write insurance for that? Well, I suppose they might, but let's assume that's the case. Would you, in that instance, have any argument that it has been waived when the policy specifically says we don't provide coverage for discretionary actions?
It would have to depend on whether or not their exclusions conflict with their definitions. It would also matter whether or not how they define incidental malpractice.
Yeah, I just want to say that incidental malpractice thing is kind of hovering out there. We don't have a whole lot of guidance on that because I don't know what it means either. But barring that, assuming that the actual coverage itself did clearly say we're not providing anything that the MTCA provides immunity for, including discretionary immunity, would you agree that that's the end of that story right there?
Well, I'll pretend that's the evidence in the case.
Oh, yeah, this is completely hypothetical because we don't have the policy.
And it was perfectly written that way.
Perfectly written.
Then I would have nothing to say.
Okay, all right, thank you.
Well, let me ask you about the amici brief that was filed by the state, which, as to the insurance question, I think what they're saying is because it's jurisdictional, one of the implications would be that you would have the burden of proof, and therefore you would lose on a summary judgment. What is your response to them saying this is jurisdictional and shouldn't be treated like an affirmative defense?
Well, you'd have to overrule the case that says that it's an affirmative defense that must be pled. Then you would have to.
We understand that.
You'd have to ignore Rule 8C, which.
Well, but do we have the power by rule to change that? In other words, if it's jurisdictional under the Tort Claims Act, do we have the power by rule to change that? 8C is just a rule we've enacted, in other words.
There would be a procedure to do that, but the court could certainly amend its rules whatever way it wants to.
Well, that's not my question. My question is, do we have the power by rule to change what is allocated to the jurisdiction by statute?
Probably.
Really? Interesting.
So one thing I would note, Your Honor, is in the reply brief, it was suggested that Rule 8C does not list immunity as a listed affirmative defense. To that I say read it again. It does. I was also challenged on the commentary where it said immunity was added as an affirmative defense and that the May 1st, 2020 commentary doesn't say that. I could understand missing that because the commentary is small print, but it's only 2 sentences long. Immunity was added in 2020 as an affirmative defense, showing that the trend is away from a jurisdictional argument and more towards having the burden on the proponents of the affirmative defense to prove it. And that's always how we've instructed juries, right? In the standard jury instructions, we tell them that the proponent of the affirmative defense has the burden of proof.
And assuming that's still the case, it's just a semantic exercise in futility to say affirmative defense, immunity, one or the other. Does it make a substantive difference here?
It would make a procedural difference, Judge, because if AG had their way, every case at the beginning is going to have a Rule 12A jurisdictional hearing before we've even conducted discovery. And my experience has been...
Well, you would be entitled to jurisdictional immunity if we follow the same rules as the Federal Tort Claims Act, which is jurisdictional. Like the insurance issue, I think the AG said, well, you better go get a FOIA before you file suit. But you could also file your suit and then ask for jurisdictional discovery to find out about their insurance policy.
You could, and you try to, even before you file your notice of claim, you do a freedom of information, a freedom of access request, but what you get is a far cry from the hundreds of pages. You usually get a few dozen pages. So you know very little early on. Then you file your suit, and you're immediately on the defensive, and you have to ask permission of the court before responding to the jurisdictional dismissal request to do discovery. And we have that in an equivalent to that in Rule 56, where if you think you need to generate another affidavit or a deposition, you can ask for it.
So from a procedural point of view, it makes sense to put the burden on the defendant who is claiming immunity because of lack of insurance coverage, who is in possession of the insurance coverage documents, to have to put them forward.
Yeah, you know, they got the stuff, we don't. So it only seems fair that they should.
They got the stuff, we don't.
So moving on to, I want to talk about Gaffner. The Superior Court declined to decide the issue of health care provider, health care facility. And the Superior Court was correct to do that because if you take a look at Gaffner, it's paragraph...
Well, do you want to address why we should even take an interlocutory appeal on the Maine Health Act security applicability? As opposed to immunity, where there's obviously a history of taking cases on immunity.
Yeah, I think they're done out of the gate. It's an interlocutory appeal.
That's what I thought your argument was going to be.
Not within any exception. And the court told them in Bean how to fall within that exception, which was to put the whole policy in front of the...
No, but I mean in terms of the applicability of the Maine Health Security Act to the jails, or whether they fall into provider, et cetera, which is their argument. There's no provider, there's no practitioner. Why is there anything that would make that appealable as an interlocutory appeal?
No, I see no exception for that. In fact, we've got a psychiatrist and a mental health professional who are also co-defendants in the federal action, who are waiting for their panel date, and our judicial economy would seem to want us to have the panel.
And the Superior Court indicated that that was essentially a fact question that needed to be dealt with, and was not going to rule on it. And is there, I guess I'm trying to figure out how that would be appealable, and whether, I think the defendants are saying that they have no other way to review the panel process.
I guess the short answer, I understand the question now. I think I misunderstood it before. The Superior Court addressed that at Appendix 2425, where it listed all the factual issues that were still unresolved. I think there were 15 of them, most of them dealing with the collaborative model. What role does the supervising licensed medical care provider have? What medical care function is the jail staff
So given all those fact questions, my question is, putting that aside, the county defendants are suggesting that it should be, the denial of summary judgment on that basis should be immediately reviewable, because there is no other way to review the panel process. The panel process is not subject to appeal.
Well, that's true for everybody who appears before a panel, and the way we deal with that on a due process perspective is when we go to court, the jury is told there was a panel, it met, and if the panel's decision was unanimous, then it gets admissible on both issues. If
Or
it's
there
not.
could be a motion in limine to exclude any process or
Sure.
something like that.
But they get their factual shot in the panel to prove that they either are or are not a healthcare provider. And then when they get to the federal court, the federal court will apply Maine law on this pendent state claim. And the jury will be instructed that the panel findings are not binding. So they have a full opportunity to litigate
So
in two
bringing it
separate
back
forms.
around, then, what you're suggesting is that it really doesn't meet the death knell exception.
Or any other exception, Your Honor.
And you're suggesting basically it's going to be the federal court that's going to have the whole enchilada.
And frankly, Justice Connors has sort of brought that up. I think the whole enchilada, this motion should have been in federal court when everything was completed. Thank you.
Thank you.
But of course, if we waited until we were in federal
Well,
court...
but let me back up on the death knell exception. With regard to the panel process, the panel doesn't enter a judgment, and it is clear that you can, I don't think there ever will be, but if there were ever a complaint in the Superior Court following the conclusion of the panel process, there can be motions in limine to keep those findings out, even assuming you lose at the panel process.
Here's why I think you ought to hear this appeal on the merits. If you don't, then claimants can bring claims against anybody under the Health Security Act, and anybody, a hospital janitor, a school security guard, can have to spend...
But isn't that how it's structured?
Well, that's why there's an exception to the interlocutory judgment rule, so that you can say, no, wait a minute, this is not the intent of this statute, it's being misused, and we are spending hundreds and hundreds of hours of people's time, thousands and thousands of dollars of people's money, litigating cases when they're not involved in the healthcare industry, they're not healthcare providers, and I think that's the reason that you ought to entertain this on the
Thank you,
merits.
counsel.
Thank you, Your Honors.
Thank you for your argument here this morning, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, I think we're in recess for the morning.